All rise. The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Hello? Hey. Hello, everyone. Thank you so much for coming out here tonight. My name is Paul Wood, and I'm one of the student directors for McBaine. I want to start by asking you to please put away any phones, laptop devices, anything that can make noise. Please make sure it is at the very least silent, if preferably off. You just heard the cry of the Supreme Court. You were about to hear an oral argument before the United States Supreme Court. Try and treat it with the respect and gravitas that deserves. This was an exceptionally competitive year for McBaine, and both the finalists, Maria Milekhina and Victoria Shahnazary, worked very hard to be here, so I ask that you all try to be respectful observers. Now, I don't have time to thank everyone who makes this possible. We had a lot of judges read briefs and score rounds, and we thank you endlessly because this competition cannot happen without you. That being said, I do want to take some time to shout out some people who, without their help, this competition does not exist. Thank you very much, Evelyn Nevin, the director of the competitions program, Caitlin Johnson, the competitions associate, Itai Tismansky, my fellow student director, Gregory Washington, our academic director, and Ivan Lazarenko, the competitions assistant. Thank you so much for everything you guys do. The competition is not possible without you. Now, without further ado, I'm going to stop talking and we'll get the show started.
Would the petitioner please come forth? You may proceed.
Thank you, Madam Chief Justice, and may it please the court. My name is Maria Milekhina, and I represent the patrons of Llano County Library System. May I please reserve 5 minutes for rebuttal? Thank you. Millions of public library patrons across the nation turn to the stories on the library bookshelves to shed light on their lived experiences. For many, finding refuge in these stories is not simply a matter of enlightenment, it is a means to survival. Llano County now seeks to disfigure the American Public Library, turning it into a conduit to suppress speech it does not like in violation of the First Amendment. Today, this court has the opportunity to uphold the long-held promises of the Constitution and save the future of public libraries in America. This court should overturn the Fifth Circuit's ruling and uphold the district court's grant of preliminary injunction for 2 reasons. First, a public library's removal of books does not constitute government speech immune from free speech clause scrutiny. And second, petitioners possess a cognizable right to receive speech free from government suppression, such that petitioners should be allowed to challenge Llano County's actions here. The district court applied this law without error, and under the deferential abuse of discretion standard of review applicable here, this court should affirm the district court's preliminary injunction grant.
I'm curious, you mentioned this case is about the removal of books. Should the acquisition of books be treated similarly to the removal of books?
No, Your Honor. The initial selection or non-selection of books and removal of books these are distinct processes that occur at distinct times in distinct contexts. Respondent's briefing abstracts away to curation or collection broadly, thereby collapsing this very critical distinction and morphing their subsequent First Amendment analysis. This court has recognized that initial selection decisions occur under certain constraints, like the scarcity of funds, that force the government to make certain content-based decisions. Removal, by contrast, does not operate under these same constraints. As Justice Blackmun noted in Pico on page 878, footnote 1, removal is therefore distinguishable from an evidentiary perspective, being more indicative of government suppression of speech. And Justice Souter noted in American Library Association on page 194 that the court could, quote, smell a rat when a library removed a book for reasons other than wear and tear and the like. This court's government speech analysis is always tailored to the particular conduct that is at issue. And
Can you smell a rat if the librarians, whoever makes the selection, don't pick certain books to start with? Why is that not something that can be investigated by the court?
Your Honor, those initial selection decisions have to occur under certain constraints, budgetary constraints and the like. And this court has held in NEA versus Finley that those decisions allow for certain content-based decision-making. But this court has also left a carve-out for as-applied invidious discrimination challenges in those instances. But here, petitioners challenge the removal of books, Llano County's removal of the 17 at-issue books. And so the government speech analysis must be tailored to that. This court has only ever applied the government speech doctrine to a very limited, circumscribed set of circumstances. And this is because, as this court noted in Mattal versus Tam, governments may invoke the doctrine to censor or disfavor viewpoints they don't like. And so therefore, the doctrine should not be readily extended. Accordingly, this court has carefully identified 3 indicators articulated in Shurtleff versus City of Boston for when government speech exists. It is these Shurtleff factors, not Moody, Hurley, or this court's other private party curation precedents that control here. All 3 Shurtleff indicators weighed together must point to a finding of government speech. So, for example, where even one indicator can be found neutral, one indicator weighs against a finding of government speech, this court has declined to adopt the doctrine. Here, all 3 factors weigh against finding that this was government speech. Under the first indicator, this court looks to whether there is a long-standing history of the government engaging in the conduct at issue to communicate with the public. Here, there is simply no long-standing history of public libraries removing books to convey a government message. Rather, since their inception, public libraries have been there to serve the needs and demands of the very taxpayers by whose mandate they were being run. Thus,
But if we were looking at it from the perspective of acquisition, and if we found that the history was that libraries made choices that are policy choices that are favoring one viewpoint over another, would that be a difficult factor for you to weigh in the Shurtleff 3-factor test?
And Justice Moore, let me see if I can rephrase your question just to make sure I understand. So with regard to whether or not libraries have historically acquired books in a particular way, will that impact our analysis here today?
Yes.
Your Honor, no, because the other 2 Shurtleff indicators as well must point to a finding of government speech here. And so if we look in the totality here, there is no history of for example, public libraries, the public would not perceive the acquisition of certain books as the government speaking to them. This is the second Shurtleff indicator. And also, there wouldn't be here sufficient deliberation as well.
Why do you say they wouldn't view it that way? The issue here is on outlier books. 90%, 95% of the library books are non-controversial. No one's going to complain. But if you see that the library is outside of that central range and is leaning more in one direction, politically, ideologically, religiously, whatever, then that the public would perceive what's going on. Why is that? I think you should concentrate on the outlier books, not in the general collection of books for the library.
Yes, Your Honor. And here, the very issue is that it is the removal of books that weighs against there being a public perception of the government speaking. So, for example, like in Summum, where there were physical monuments permanently placed on government land, and observers could readily perceive that. Or in Walker, government-ratified slogans put on license plates. Here, removal consummates a complete erasure such that the patron looking at the empty bookshelf would not be able to readily perceive a message, let alone a speaker. Libraries routinely remove books for wear and tear, something that would indicate that patrons, not the government, found the book to be particularly worthy. And libraries routinely remove books for failing to circulate for 5 years.
So are you saying in the facts of this case, the public wouldn't think that these books were being removed as a result of government policy?
Your Honor, the government speech analysis looks to what the public would readily and reasonably perceive with regard to the conduct at issue here. Now, you mentioned government responsiveness to policy, and that hits at a very important point in this case and something that Respondent's briefing emphasizes to a large extent. In West Virginia Board of Education versus Barnett, this court held that the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy. So allowing electoral outcomes to somehow justify the stifling of minority viewpoints would strike at the very heart of the counter-majoritarian ethos.
That was not government speech. The question there was whether you could force people with certain religious beliefs to participate in the Pledge of Allegiance.
Yes, Your Honor, but the court articulated a premise that is at the very heart of the First Amendment, the counter-majoritarian ethos there. But additionally, in New York Times versus Sullivan, this court also noted that the framers provided for free speech precisely to protect disfavored ideas of the minority from the tyranny of the majority. And so here, the library is there to serve the entire community. And so allowing the board to remove books and allowing that to be justified based on the fact that these are elected representatives would begin the erosion of core fundamental First Amendment freedoms that are important in this country.
So I'm a little bit confused about whether that's an argument if we assume this is not government speech, that they're very fundamental First Amendment rights that are being infringed. But if this is governmental speech, then the government can do whatever it wants. Is that right?
Your Honor, so exactly. If this is found to be government speech, what will happen is that mass removals of private speech, counties will be able to remove books, and that conduct will be entirely immune from any free speech clause scrutiny moving forward. So the government could readily discriminate based on viewpoint, pulling books off bookshelves left and right. And so that is why this case is so important.
But the first, I thought you were responding on the first of the Shurtleff factors, and that was what the public perception would be. And I'm trying to see in the facts of this case why the public would not see that it was the governmental actors who were removing the books. It wasn't, it was the government that was deciding these things. Explain how that factor supports your position.
Yes, Justice Hartz, and I apologize, I will clarify. So with regard to the first Shurtleff factor, which we started out, that was with regard to whether there was a long-standing history of public libraries removing books, and that pointed to a negative. Now, moving into the second Shurtleff indicator there, we're looking at public perception. And so here, the public would not readily perceive the empty bookshelf as a message, let alone identify a speaker with that.
Even in the facts of this case, they wouldn't see, that's a book I had wanted my kids to read or I wanted to bring home, and it's not there. It was that observation that led to this litigation, isn't it?
Yes, Your Honor, but what respondents argue and how the Fifth Circuit construes this is that the government message here is that the removal indicates the government thinks this is not worthy literature. But the problem with that is that patrons looking at the empty bookshelf could readily perceive it as not being guided by the government speaking, but for example, patrons expressing their thoughts on the worthiness or unworthiness of a book. Books are removed all the time because they're worn and torn. That would indicate patrons thought that the book was worthy, or they're removed all the time because books failed to circulate, showing that patrons would have thought the book's unworthy. So there's no readily identifiable message in the removal, let alone a speaker. And this is something this
What if the county library board did this publicly and said, we want these books, the particular books, the 17 books that are involved here involving race and gender and those kinds of issues, we want them removed. So my hypo is that the county library board says publicly, we want these removed. Wouldn't there be then a public perception that this is government speech? In contrast, arguably, with the facts of this case, which were that it was done somewhat surreptitiously with all sorts of details that you can provide. But if in my hypo, wouldn't the perception be it's government decision-making and government speech?
Justice Moore, so in your hypothetical, this is assuming that all patrons are going to somehow view a press release, be aware of it, but this court always looks to what is readily and reasonably perceivable. For example, in Shirtlift, this court looked to whether observers of the flag raising would look at the persons congregated at the base and associate that flag with either the community group or the government. And so this court's government speech analysis always looks broadly and looks to what people would readily and reasonably perceive. And additionally, Justice Moore, thank you for highlighting the facts here as well, because here what happened was this wasn't a deliberate and meaningfully the government was not meaningfully involved in this decision. And this goes to the third Shirtlift indicator here. Pages 36 and 37 of the record indicate how the community group here was the one that reviewed, selected, and curated the list of books that directed the library book removal process. The library staff's review of books was exclusively limited to this list, and Director Millam's testimony indicated that she pulled these books precisely because the community group highlighted them and they were on the list.
Wasn't she also under pressure from, and you can correct me on my nomenclature, but the county judge who was the person in charge and the commissioner. And so these public officials were pressuring, as I understand the record, were pressuring the librarian to remove these books. Granted that it was this community activist group that thought that the potty books were bad for children to be exposed to, and the race books were bad for everybody to be exposed to, and the one about the KKK was bad. But because there was this involvement of the key governmental officials in Llano County, it's hard to say that this is totally private people, even though private people started the ball rolling, as it were.
Justice Moore, so here the district court found on pages 62 and 63 of the record that Llano County, the commissioner's court, quote, quickly and uncritically rubber stamped the community group's decisions wholesale. And when this court looks to the third Shirtlift indicator, it is looking to whether the government exercised meaningful involvement and deliberation so as to make this a form of government speech, ultimately making it clear that it was the government wishing to speak for itself.
So you're saying the government was not voluntarily speaking for itself, this was members of the community doing this?
Yes, Justice Hartz.
But isn't that the way government works? Government officials do what their electorate pressures them to do.
Justice Hartz, the issue here is that this is entirely unlike, for example, Johann's, one of this court's first government speech cases, where there, the government action stemmed from a legislative scheme. The secretary was involved in the congressional beef promotional ads from beginning to end and was meaningfully involved in the entire message there. Here, what we have is more like in Shirtlift, where the court noted Boston adopted a come one, come all policy on page 258, such that the city lacked meaningful involvement so as to turn the flag raising program into government speech. And here, the commissioner's court's essential rubber stamping and quick and uncritical adoption of the community group's viewpoint-driven decisions here with regard to the books does not arise to the level of making this government speech.
How many the arguments that you're making are very fact specific, and I'm wondering if, like in Shurtleff, where the court didn't say all flag poles or all flags are forms for private speech, they can be or probably usually government speech, but in this particular case, in the way that this particular government had used its flagpole and opened it up, and that in the facts of that case, it became a forum for private speech. So how much of your case is driven by the specific facts of this case and in determining whether the particular removal here was government speech versus censorship of private speech? Should it matter whether there was a deviation from the existing policies and practices?
Yes, Your Honor. This is very fact-specific. In Shurtleff, the 6 justices applied the 3 Shurtleff indicators, but noting this was a holistic inquiry, the government speech inquiry is holistic and driven by the case's facts and context. And so facts differ, and so the analysis may not always be identical case to case. And this is important because, again, when we're thinking about whether government speech applies to a particular form of conduct, we're looking at things like public perception. We're looking at things like how much was the government meaningfully involved here, how much selectivity and deliberation did it exercise. In Walker, for example, the court really closely looked at what was the process for Texas's approval of the license plate slogans and so on. And so here, Your Honors, all 3 Shurtleff indicators do not point to a finding that what Llano County did here, these book removals, were a form of government speech. Finding government...
Could we also be somewhat result-oriented as the Supreme Court here and say the consequences of it being labeled government speech would mean that there's no First Amendment protection whatsoever, that the government could remove all books written by Republicans from the library, or all books written about any particular historical development that might be important in the development of our history, and that if this is government speech, all of that would be allowed. Is that something that we should be considering?
Absolutely, Justice Moore. This is something...
Isn't that typical of government speech? When a Democratic administration or Republican administration puts out literature for their agencies, they're not going to include what the opposite party would like to say in that. So how is that, if that's going to be the important criterion, then you've eliminated the government speech doctrine altogether, have you not?
Justice Hartz, that is absolutely correct with regard to, when there's a political party and they're putting out their own statements, their own documents. The government to govern has to speak. This is why the doctrine exists. The issue here is that the county is invoking the government speech doctrine to essentially immunize large-scale removal of private speech. And so when it comes to the government speech doctrine, this court is very wary, and Justice Moore, this goes to your earlier question, this court is very wary of that. And for example, in Mattal versus Tam, this court considered how holding that trademark registration in that instance was a form of government speech, would then put other forms of government registration at risk of also being held to be government speech. And so here, expanding the doctrine would sanction large-scale viewpoint discrimination and immunize the removal of private speech anytime government actors...
How do you deal with the consequences, the flip policy consequences of saying that this is merely a forum for private speech in which all the court's precedents say then there cannot be viewpoint discrimination? And so is it then that does the other extreme come to bear where the library then must, include books, even which the, vast majority, the Fifth Circuit kept pointing out, the most, terrible screed from, the Ku Klux Klan or something like that. And how would they deal with the flip side, what would be the limiting principle, and how could you square that with your view that this is not do we have to invent a new standard, a new type of form? Is this, some kind of combination of government speech and, forum for private speech? I mean, is there, how would we do that?
Justice Sung, so I'll answer your question in two parts. First, when it comes to acquisition, petitioners are not challenging Llano County's ability to make initial acquisition or selection decisions for its book collections. But second, when it comes to the removals, this court has already addressed that issue in Board of Education versus PICO. And there the court held that there was a First Amendment right to receive speech free from government interference or suppression based on viewpoint. And there, essentially, the standard articulated per PICO is that when a government actor removes a book, its motivations in doing so are critical. And the inquiry becomes, did the government actor remove the book with a decisive factor, substantial motivation being disagreement with the viewpoints or ideas in the book? So at bottom, this is a viewpoint discrimination standard.
Well, let me ask you about PICO. What did this court say about government speech in PICO?
Your Honor, so PICO was not a government speech case.
That was not considered. So they never, that's a doctrine that's developed over time. We learn things over the 40 or 50 years since PICO. No one was thinking in terms of, well, is this government speech? And so I don't see how PICO really addressed the central issue in this case, either of the central issues, whether it's government speech or whether culling the book collection is an editorial expression.
Justice Hartz, yes, PICO did not grapple with the government speech doctrine. We look to PICO once we've concluded our government speech analysis here per the Shurtleff indicators and per this court's government speech doctrine precedents like Mattal versus Tam. Once we know this is not government speech, we are dealing with the government putting its finger on private speech already available on the bookshelves and interfering with its availability based on viewpoint. And this is where Board of Education versus PICO comes in, because this court dealt squarely with the issue that we're facing here, where petitioners are asserting a First Amendment right to receive speech free from suppression.
So do you have a problem in PICO? And I know you're moving into your second argument. Do you have a problem in PICO with figuring out where the various justices are? And as Justice Hartz points out, it was 40 years ago. So we're new justices and we get to decide. We do have the statement from Justice Brennan and from Justice Rehnquist saying that you can't have viewpoint discrimination in the type of thing of removal of books from a school library. So should we make that the law now? Or is there a difference between public libraries and school libraries?
Justice Moore, I have two answers there. First, with what to do with the PICO holding. It was a fractured opinion, but under Marks versus United States, we find the binding rule in the narrowest grounds. And the Fifth Circuit agrees that this is justice.
But we're the Supreme Court, so we don't have to follow Marks, do we?
Well, Your Honor, that is the precedent. And I see that I'm out of time. Is it okay if I conclude?
You can answer the question about, assume that we get to decide free of PICO.
Okay.
Because it was a fractured decision and it's 40 years. If you want to just give a 1-minute summary of your argument on that point, on how we should resolve the First Amendment issue here.
Yes, Your Honor. Well, even outside of PICO, this court has for decades upheld the public's right to receive speech free from government interference based on viewpoint. The case on point here is Lamont versus Postmaster General. There, the court held the government could not detain suspected communist political propaganda, finding this abridged willing recipient's First Amendment right to receive speech because the government sought to control the flow of ideas to the public. And this was later reaffirmed in Virginia State Board of Pharmacy, where the court explicitly rejected the argument that, for example, people can just go get that same speech elsewhere, and that alternative avenues to access somehow remedy the government's initial abridgment at the first instance. For example, there the court noted in Lamont, it could have told the recipients to go get that communist political propaganda themselves, but they said that no, the government had to vindicate that right. And so in sum, Your Honors, not only does the government speech doctrine not apply here, but petitioners do possess, and this court has long recognized, a right to receive free from government suppression based on viewpoint. In sum, we respectfully ask that you overturn the Fifth Circuit's ruling, affirm the preliminary injunction, and save the future of public libraries in America. I await your questions on rebuttal. Thank you.
Thank you.
May I proceed?
Yes, please.
Good evening, Madam Chief Justice, and may it please the court. My name is Victoria Shahnazary, and I represent the respondent in today's case, Llano County. This case is about curation, not censorship. It's about a government that built the bookshelf, bought the books, and chose what belonged there. Because in this case, Llano County didn't pass a law saying that the citizens of the town couldn't read certain books or stop publishers from putting out ideas that it disagreed with. It simply decided that certain books didn't belong in their own collection. That distinction matters. Because the First Amendment draws a crucial line between restricting private speech and letting the government speak for itself.
So does the government speak for itself when the library has all sorts of books, some of which are in favor of the Second Amendment and some of which are against the Second Amendment? How do we know what the government is saying there?
Yes, Your Honor, and that's important to understand that the message of the government in this case is not actually every individual book or every underlying private speaker, but rather the collection itself, saying that this collection of books is worth reading. And when a book is removed, this is no longer worth reading. And
Well, how can you say that about some of the 17 books that were removed?
Your Honor, after, and we'll get into the short-lived factors to address this information a little bit more when it comes to government speech, but after public complained about these books on the shelves, the democratically elected government made a choice to remove these books to respond to the community concerns.
What evidence there is that the public perceives the government to be speaking in its choice of books?
Sure, Your Honor. So that goes towards the public perception factor in short-lived. And you actually have to look no further than pages 60 to 62 of the record to see why the public perceives the collection itself as belonging to the government. Because the relevant evidence in this case shows that at no point throughout the facts of this case did the public ever complain to the authors or the publishers of the books themselves. They went directly to the library because they had an issue with the books that were being retained in the collection itself.
Well, I can understand a complaint about the book being available or not available in the library, but that doesn't seem to me necessarily to say that we perceive the government to be speaking the government's own viewpoint by the inclusion or exclusion of a book.
Yes, Your Honor. Well, when you look at the facts in this case, the patrons who complained to Llano County had an issue with the viewpoints put in the books. And they went to the librarians in the elected commissioner's court and they said, we have a problem with these books being on the shelves. And the government listened to them, as a democratically elected government should, and decided to remove those books from the shelves. The very fact that these patrons went directly to the government to complain, as opposed to the authors or publishers, shows that they're interpreting the books on the shelves as the government's message, their collection. Now,
Well, that was the people who were complaining. Does that mean that all people in Llano County think of this as government speech?
yes, Your Honor, and that's exactly why this suit occurred, because the public believed that the government was speaking through taking these books off the shelves. At any relevant point that we look at this case from, the public is perceiving the government to be speaking, both in the books that it's acquiring and the books it's removing.
Doesn't that support then the government speech being everywhere, meaning that there is no First Amendment protection for anything?
No, Your Honor, and that goes towards the other three factors of shirtlift, which I'll get into now. Now, contrary to...
Before you do that, what is the purpose of the government speech doctrine? Why do we not put First Amendment restrictions on government speech? What's the theory behind that? And I'll explain why I'm asking that question after I get your answer.
Yes, Your Honor. Well, this court in Walker said that when the government speaks, the appropriate check for that speech is at the ballot box, not in the courthouse. And this is practically exactly the type of case where that democratic check exists. And to talk about that a little bit further, Your Honor, every relevant player in this case is either appointed or elected. The commissioner's court is a group of elected officials, both the judge and the commissioner.
Well, the fact that it can be cured by an election doesn't determine what the constitutional right is. You could have a racist government and say, well, we can vote them out of office. That doesn't mean that there won't be an equal protection claim there. I'm curious why we have said that if it's the government speaking, then we're not going to restrict it under normal First Amendment constraints. And what's your theory behind that? And I'll go ahead and explain why I'm asking that. Because you have a two-part argument, as I understand it. One, this is government speech. Well, one, government speech is protected, and curating books is speech. But I don't think it follows necessarily that just because the government is doing it, that curating materials in a library should be protected for the general reasons that apply to government speech. If government speech is protected and not constrained because the government should be able to get its message out, why does that rationale apply to curating books at a library? Why can't we say, yeah, government speech, but this is government speech? Ordinarily, we say the government can speak as it wants, but when you're talking about curating books, it's a different story. Why can't we make that distinction?
Yes, Your Honor.
That was too long, I'm sorry, but I want...
No worries, Your Honor. Well, I'd like to address this court's prior precedent in Arkansas Education Television Commission v. Forbes, where this court held that a broadcaster's decision to select or exclude certain programs from broadcasting was actually a form of speech. It was that editorial discretion, the curatory power that they had in selecting which programs to air, that made it a form of speech under the First Amendment.
And counsel, there's no dispute that when a private entity or individual makes editorial decisions, they are engaging in First Amendment activity. The whole point, I think, of why we're here, though, is that the government could be different. It is not necessarily similarly situated to a private, newspaper, broadcaster, or even private library. So the power of the government, the resources it brings to bear, the possibility of censorship are all things that could mean the same conduct. Curation is not the same thing legally for constitutional purposes. So why should, I think this is just a variation on the question of Justice Hartz, which is, why would we extend the concept of government speech to library decisions and for a public library?
Yes, Your Honor. Well, this goes to the administrability of trying to put a content neutral or viewpoint neutral standard in public libraries. And I have 2 points on that. The first is that books themselves are expressions of viewpoint. When Llano County or the librarians are choosing which books to acquire or which books to remove, they're necessarily making distinctions based on the viewpoint and content of what is in those books. It's impossible to ask a library to make all of its collection decisions on viewpoint neutral and content neutral sounds when the very medium that they're trying to create, the whole purpose of that is to espouse viewpoints.
Right. Well, in our First Amendment doctrine, we have a very common understanding of where there are things that are facially viewpoint neutral, content neutral, but then we might look at the specific facts of a case and say, but despite the facial neutrality, we see a viewpoint discriminatory purpose, and that offends the Constitution. So one of the arguments I hear from your opposing counsel is that essentially looking at the facts of this case, even perhaps if one could assume that when the government is selecting books, it is in a sense speaking, and it can engage in some sort of viewpoint discrimination, but when it has selected a range of books and it has a policy and a practice for the removal of books from that collection, and it deviates from that under the circumstances here, the facts here show a viewpoint discriminatory purpose. So that this is not government speech. It is, in fact, crossing the line to censorship in a very fact and case specific way. Why doesn't our doctrine allow for that?
Yes, Your Honor. Well, 2 points to that question. The first is when you look at the record itself, these books, which half of which, as Justice Moore put it, called the potty books, did not come from a list that was 17 pages that referred to a variety of LGBTQ as well as critical race theory books. There were about 9 books that came from that list that was over 17 pages. There's nothing in this case to suggest that the Llano County Public Library removed every single book on those 17 pages. We can see that in the record on pages 60 to 62. Instead, they were removing them based on issues they had with the idea that there were naked bodies in those books or other things that they felt would be inappropriate to patrons viewing their collection.
So I understand your answer is more, well, if you look at the facts of this case, we're not engaging in purposeful viewpoint discrimination, or that the facts don't reveal that prohibited purpose. But I guess, could we, even assuming as a background general legal principle that the government is speaking when it makes curation choices in a public library, that there could still be a fact-specific case in which those choices are actually viewpoint discriminatory and violate the First Amendment? Do you understand that, my question?
I do, Your
Okay.
Honor. Now, on the respondent's side, it's our contention that you cannot make viewpoint neutral decisions when you're removing or acquiring books. But to address your concern on a more practical level, if, for example, a public library chose to remove all books by Black authors or all books that had a female main character, that would be an equal protection claim under the 14th Amendment.
Well, apart from equal protection, we can think of other things. And in the PICO decision, both Brennan and Rehnquist, who are speaking for 7 justices at least, both of them said that you couldn't have a government library removing books by Democrats and not by Republicans, and books by Black authors and not by white authors. So if we take away the idea of equal protection, I don't know that equal protection protects Republicans and Democrats. So let's assume that it doesn't. Haven't we given clear indication that extreme viewpoint discrimination is prohibited by the First Amendment in removals from at least school libraries? And if that's the case, why not from public libraries?
Your Honor, I'll answer that question in 2 parts. The first is I want to address Justice White's concurrence in this case.
Yeah, but I don't want to talk about Justice White.
Yes, Your Honor.
I want to talk about the other 7. Brennan writing for 4, Rehnquist writing for 3 dissenters, but he said he cheerfully conceded this, that you could not remove books by one party's authors and not by the other parties.
Yes, Your Honor. Well, as an initial matter, PICO took place in a school library, which is very different from a public library.
Well, isn't there more room for governmental restrictions on what little kids read in school libraries than there is in public libraries, where parents can control their children because they bring them to the library, and where adults can read and should be able to read under the First Amendment whatever they want to read?
No, Your Honor. It actually makes sense to have stronger First Amendment protections in the context of a school library. And the reasoning for that is twofold. First of all, children cannot vote. The majority of them dealing in PICO could not go to the polls and elect a new school board who could help deal with removals in the way that they saw fit.
But aren't you ignoring the educative function that all of the opinions in the PICO case dealt with? All of them talked about the role of educators and having a special role in trying to decide what to teach kids. And then you have the school library, which offers books that the kids can check out. And so it would seem to me, at least, that you would have more latitude for the governmental body restricting the books in the school library than you would in the public library. Tell me where I'm wrong.
Sure, Your Honor. While I understand your concern, the difference between a school library and a public library is that students must go to school. They're required by law to seek books in a school library to exceed that type of inquiry. A public library is an optional service put on by the government. And that's really where PICO differs from the public library in this case. And furthermore, Your Honor, PICO was decided in 1982, which, as Justice White notes, was before a lot of First Amendment jurisprudence had even been considered. There was no government speech doctrine at that time. There was no forum analysis at that time. And Your Honor, that decision even came out before the internet was available to the public. The world that the PICO court was dealing with in 1982 was fundamentally different from the world that we're dealing with now in 2026.
Has any court other than the Fifth Circuit plurality said that the removal of books from the public library is a form of government speech? Is not the plurality of the Fifth Circuit here the outlier?
They are the outlier, Your Honor, but only a handful of circuits have addressed book removal cases, and those cases have involved public schools. And therefore, really, the Fifth Circuit is the only one that exists that's combated this question.
Let me ask you, I don't read PICO the way everybody else seems to. It doesn't seem to me that it's concerned about viewpoint discrimination, because both the majority opinion, or the Brennan opinion, and particularly the Blackmun opinion, make a point about the need for schools to advance morality, good citizenship, things like that. They were focusing on narrow political discrimination. Is there that sort of discrimination present in the record here?
Yes, Your Honor. There is an argument to be made that throughout the facts of this case, the Llano County Public Library decided to remove certain books due to partisan ideals. And that's exactly the type of reason why the government speech doctrine applies in this case. And so I want to shift back to talking a little bit about those three shirtlift factors and why it applies here. Now, the first one, Your Honor, is the history of the expression at issue. So who over time has traditionally controlled the expression at issue, which in this case of a public library is the collection. And the fact is, Your Honors, at no point throughout the entirety of this country's history has anybody other than the government controlled what goes on the shelves of public libraries. Dating back to when the first library was founded and they were making decisions on how to improve and instruct citizens, the government has been the only one that has ever made those distinctions.
Is there a history of the government choosing to either acquire or remove books that are only one-sided on a particular significant topic?
No, Your Honor, but in this case, there's no evidence that that occurred here either.
Well, there's a lot of conflicting evidence, and the district court made certain findings, but it was at the preliminary injunction stage based on, the different testimony of the two librarians here who really did say different things. And we take the facts on the Court of Appeals, we give deference to the district court's fact finding. Should we be giving deference to the district court's fact finding here?
No, Your Honor, and the reasoning is this. The district court abused their discretion when they chose to analyze libraries in a viewpoint discrimination or content discrimination standard.
But that's a legal question, not a deference to the factual findings.
Your Honor, what the district court says on page 62 is that the weeding guidelines must have been pretextual because the government addressed community concerns in taking the books off the shelves. But if we look at the text of the crew manual, which are the weeding guidelines in this case, the crew manual has a significant section actually dedicated to how the government and how libraries across Texas should respond to community concerns.
But I think part of my trouble with the argument you're making is that you're saying that there's a history of the government selecting which books are on or off the shelves. Certainly that as a factual matter is true, but the question of whether that is speech or whether people understand that to be speech is different, right? And I think there's going back to my earlier question, just because we agree it's speech when it's coming from a private actor, I don't think necessarily means it is government speech. And one of the justices have explained the danger of overexpanding the concept of government speech because it can so easily become a vehicle for censorship. So what in this case seems to exactly present that question. If we over expand, right, the concept of government speech, we run directly into the problem of then it becomes a vehicle for censorship, right? So that is, what can, in a sense, I guess my question is, I understand that choices have to be made, right, and the government is, because it's a public library, it is by definition the government making those choices. But how do we give the government the fact that we must give, and we do give governments the latitude to make those choices, doesn't necessarily mean then that we have to give it full latitude with no First Amendment scrutiny at all?
Your Honor, when we're looking at how First Amendment scrutiny would apply in this case, there are other amendments, for example, the 14th, that can handle this type of issue if it becomes to the point where the government is overstepping. And I'll return back to my argument about the democratic process in this case, because the reason that this court has said that it's felt comfortable extending the government speech doctrine in cases like Walker, for example, is because these types of decisions can be checked at the ballot box. And here, at every relevant step, the commissioner's court, the librarians, even the Texas State Archives and Library Commission, which is appointed by the governor, every relevant player in this case is either appointed or elected.
I've been wondering about this fact issue. Is there an ability for the people who wanted the books to be present to appeal to a court or a higher authority within Texas?
No, Your Honor, but those people are free to acquire the books in any other way, whether that's...
If they're rich enough to buy books?
No, Your Honor. The books were both available by interdistrict loan, which they could pay a small fee to have that book delivered to their house, or in 2026, which was not a concern with the PICO Court of 1982, 96% of Americans have access to the internet in their home. And if we're worried about the suppression of ideas from a First Amendment standpoint, which is really what the PICO plurality talks about and focuses on, it's unfathomable that we could suppress ideas in a society where you can access billions of ideas for free on Google at any time. So while the specific book may not be available behind a paywall, the idea within it certainly is through a variety of other channels.
So are there alternative books to these 17 that espouse the same points that these books espouse that are available in the Llano library?
Your Honor, it's difficult to say because when you look at a book of 300, 400 pages, which is what most of these books are, there will inevitably be viewpoints in each of them that aren't available in any other book. But there are other books on the shelves that represent LGBTQ stories or critical race theory books. There's no evidence on the record to show that every single book in that 17-page list that was circulated by Representative Krause and then adopted by the patrons who eventually complained about the books was removed from the shelves.
So we may have evidentiary questions that we should remand once we figure out the law. But you're saying that there may be the same viewpoints that are available in the library, and should that make a difference?
No, Your Honor, because it's respondents' contention that regardless of what books are on the shelves and which are not, that's the government's message of what books in a library are worth reading. There's no reason to remand for further factual inquiry in this case because we have all the facts on the record that we need in order to say that the government is speaking through its collection. And to show that, I know we've talked about the first two short-lived factors quite a bit, the history and the public perception, but I want to get back to that third one, which is who has actively controlled the messages that the collections in public libraries send. And when we're talking about that third factor in this case, the reality is that nobody other than the Llano County has ever controlled what books are in the collection and what messages are being sent to the public. Now, this is different than the case Ms. Milekhina cited, where in Shurtleff there was no internal guidance, or no written policies about which flags would fly. That's not the case in a public library, where we have the crew manual, which talks about community concerns and how to address those.
Who wrote the crew manual?
The Texas State Archives and Library Commission, which is appointed by the governor.
And how long-lasting? When was that first adopted?
There have been 12 editions dating back to about the late 1900s.
And they, in terms of, one of your points has been that this type of book has been culled, has been weeded out before. Is that evidence in your record that similar types of books have been culled before? And if so, how long have they been culled?
Your Honor, the Llano County Public Library has not made a similar process of removal. It says that in the record, as they did with these books. But just because the government hasn't decided to remove books to change its message in the past doesn't mean that it forecloses them under any prior precedent of this court from changing that message in the future.
No, but the shirt-left factors do tell us to look at the history and the perception and the experience. And so if this is a relatively new thing, then saying that the crew factors say you can consider something having to do with the message may not be that significant.
Yes, Your Honor. Well, under summum, the defining part of this inquiry was whether or not the county in summum had exercised final approval authority over the monuments that were going to go onto the park. Regardless of whether this was a routine weeding process or not, the Llano County Public Library and the government, in conjunction with that, have exercised that final approval authority over what books go on the shelves and what books they want to remove.
Well, if I understand your argument correctly about how the government is speaking here and how it's been perceived to speak, it's through the crew manual and through a steady historical practice of essentially implementing the policies that are captured in the crew manual. I understand there's a factual dispute in this case about whether there was a deviation from that crew manual and the policies and practices. Why couldn't that be then evidence then that this isn't government, the removal wasn't government speech, it wasn't consistent with the perception and understanding of how the government has been speaking through the curation of the library and has crossed over into censorship?
Your Honor, if anything, this points actually further to a finding of government speech, because the government did something that was so inflammatory in a community that people are taking it to the courts and going to the polls to vote and change the way that they operate in the future. And I briefly want to talk about what happened actually after this case was filed, because I think it's relevant also in understanding the administrability concerns in not labeling collection decisions as government speech. Now, in April 2023, the county actually held a hearing in Llano County about whether or not they would have to shut the library down. And the reasoning for that is that out of their $450,000 budget that they have for the year, in the first 4 months, they had spent over $100,000 of that budget just trying to defend this one suit. They were making cuts to social services, to indigent people's care, and to a variety of other programs in Llano County just to keep the doors open.
Well, I guess part of the trouble I see is that there's again, I think I could accept that there has to be some sense of government speech in terms of the selection and curation decisions that you're talking about. But I guess what I'm trying to say is there a standard? Is there a fact and case-specific scrutiny that we can engage in to confirm that what is actually happening here is government speech and not crossing the line into prohibited censorship under the First Amendment, and that to the extent you're saying the government is speaking through the adoption of the crew policy and the implementation of the crew policy, the more consistency there is with the actual policy and practices that have historically been the government speaking under your theory, the more I would be inclined to say that that is the government speaking. But the more that there is a deviation from those things, the more then I would say I think the argument is that we have a very case-specific situation in which the government is not actually speaking but censoring.
Yes, Your Honor, this is no different than really any other democratic process that we look at in the United States, because every year when we have, or every 4 years or 8 years when we have new presidents, they inevitably choose to use new channels to convey their message or choose to
So
not.
they could modify the crew policy through a standard governmental process of modifying a policy, right? I mean, I think the more standardization, the more things were done in the way that the government normally operates, the more it seems like the government is actually doing what governments normally do, right? And speak, and not crossing the line to a question of a violation of the First Amendment.
Yes, Your Honor. But in this case, the fact that the government was removing those books and people perceived the government removing those books and had an issue with it really speaks towards how the community is perceiving this as government speech, that they have a problem with how the government is choosing to stock its shelves. And with the limited amount of time here, I briefly want to talk about the right to receive that's not enumerated in PICO, because historically, throughout time, the right to receive information has protected private speakers and private listeners without the government stepping in the middle and stopping people from receiving that message. For example, to use the case that Ms. Milekhina did in the case of a post office in Lamont. Now, unlike a post office that promises universal mail delivery, a public library has never, may I briefly conclude?
Yes.
A public library has never promised universal access. And the equivalent in this case would be if the county walked to a public park and stopped authors from handing their books out to the public. Now, with that, Your Honor, we ask that you affirm the Fifth Circuit and decline to constitutionalize the shelving decisions of public libraries. Thank you.
Thank you.
In her remaining time together, I would like to make 2 points. First, broadly going to the government speech doctrine issue here. Now, Respondent's counsel repeatedly mentioned collection, curation, and Your Honors, it's clear here today that we're seeing 2 different processes here within that. We're seeing acquisition and we're seeing removal. What's squarely before the court here today is removal. But what we need to consider is when we're looking at the government speech doctrine, if we're allowing acquisition and removal decisions to be encapsulated within that doctrine, we are entirely immunizing all government decisions regarding what goes on and goes off the shelves across the country, and not allowing for any viewpoint discrimination challenges to be brought ever. Now, there was talk about the 14th Amendment and other areas of the Constitution, but once we even begin to consider that, we've already conceded that the erosion of our First Amendment free speech clause rights have begun. Now, Respondent repeatedly mentioned the ballot box. The ballot box is not an indicator or a requirement for government speech. It has only ever been used as an ex post policy justification. In Walker, page 207, this court said, to the extent the ballot box can serve as an ex post check on government speech, it can only do so if the free speech clause is able to help produce informed opinions among the public such that they are able to check the government. Respondents' arguments about the ballot box become self-defeating when involved to support the government's very targeting of speech based on viewpoint. Now, my second point here today goes to the broader motivational inquiries here and the concerns about administrability. Now, Justice Moore, you mentioned the standard of review we're applying here today, and that is the abuse of discretion standard for the preliminary injunction pursuant to which this court owes deference to the district court's factual findings. And I would like to remind the court of those factual findings. On page 35 of the record, the county removed books mentioning body parts because, quote, they promoted grooming. The respondents removed, quote, CRT and LGBTQ books because they were, quote, pornographic filth. This is on page 57 of the record. Page 63 of the record. The district court found that while respondents are claiming this was all done pursuant to weeding and pursuant to the regularly applied crew criteria, the district court found that those very same criteria were not applied to a plethora of books that have been allowed to remain on the shelves for years. Instead, it was these 17, quote, CRT and LGBTQ books that were pulled, the pornographic filth.
Counsel, I do want to get back to a question that ultimately troubles me the most about your case, which is, I think you keep trying to cabin off the selection decisions and saying you're not talking about selection, you're only talking about removal. But I'm not sure how we get to a place where what we can distinguish it between them in a principled fashion, or what is the doctrinal basis or standard by which we would say those two things are different? Is the government speaking when it's selecting, and it could entirely say, like, we're not going to choose these books because we don't like them, we don't like the viewpoints that they express. But once having chosen them at one point in time, they can never remove them on that same basis. Is that your argument, or are you saying there is some limit to even the selection decision that we have to consider?
So Justice Sung, when it comes to a library's initial selection decisions, I'll note American Library Association, a case upon which respondents heavily rely, on page 205 said that the Finley line of cases apply to the library's discretion in selection decisions. What this means is the government is allowed to make certain content-based decisions there because it is forced to operate under budgetary constraints and the like. But within those lines of cases, we have always left a carve-out for as-applied invidious discrimination challenges. And so that is a standard that this court has already articulated that is applicable to such initial selection decisions. And removals here we're treating them differently because the government speech doctrine analysis has to look at the particular conduct being challenged given how fact-specific it is. But also, Your Honors, removal, as Justice Blackmun noted in PICO, is distinguishable and important from an evidentiary perspective, being more likely to show an impermissible government removal based on viewpoint. In sum, Your Honors, to use Justice Souter's words, the court can smell a rat here, and we ask that you please affirm the district court's grant of preliminary injunctions and save public libraries in America. Thank you.
Thank you.
Thank you both for an excellent argument on both sides, and the court will adjourn for some deliberations.
All right. Thank you so much. What a wonderful round of applause. We would ask you please remain seating so the judges are able to get out and go deliberate. Then they'll come back and announce a winner. In the meantime, though, we're going to hear from Jacob Cantor, who's going to talk about the importance of legal writing and announce the winner of Best Brief. So, Jacob, are you here? I see you coming up.
Hi, everybody. Can we get another round of applause for the incredible job that was just done? Really, really nice. Really well done. Thank you for being here. I'm Jacob Cantor. I'm a lawyer at Kroll & Mooring. I'm in our San Francisco office. I do litigation and privacy and cybersecurity. If you're interested in those topics, I'm happy to talk about them with you if you'd like. But I'm here because my firm sponsors the Best Brief Award. And so I come up here and I give the award for the best petitioner and respondent briefs. And also I give like 100 seconds on the importance of legal writing. And so if you give me a moment, I'll do that. As a young lawyer, the most important skill you have is your ability to write. You're going to be dealing with busy people. You're going to be dealing with people who have a lot of responsibilities, who maybe don't trust you. And that's crazy because you're all really smart and highly competent, but they won't. How do you overcome that? You write well. You're going to be dealing with judges who are incredibly busy, worried about the litigants in front of them, and maybe don't trust you. How do you deal with that? You write well. You're going to be dealing with clients who, if you're in private practice, are spending probably a lot of money on you. If you're doing criminal work, are dealing with serious issues around, their criminal liability, who have a lot on their minds and are looking for clear, concise answers to complex, thorny, and sometimes stressful issues. How are you going to deal with that effectively? You're going to write well. And this is the most important time in your practice or in preparing for your practice when you can learn to write. You should write every day. You should write for every reason. You should write when you wake up. You should write when you're on the bus going to school. I really mean it. I really mean it. It should be constant. It should be all the time, because this is how we communicate with each other. The oral presentations today were incredible. I really loved them. But that's just a part of it. It's a small part of it. And as you know, the written portion of this class is incredibly important too. You got to do it. You just got to do it. And let me just say, as thinking about preparing for this speech, I was thinking about how easy it is not to write these days, because we have ChatGPT and Claude and all this stuff that will write for you. All the more important that we learn to write well so that we can know what's good, what's bad, when it's kind of bullshit, right? So every day, please write about whatever you want. It's worth it. So without further ado, I had the privilege to read a couple of the petitioner and respondent briefs, and the ones I read were all excellent. Truly thorny, challenging issues, but all really well done. And so congratulations to everyone in the class. But you only get 2 winners. So congratulations to the winners of the Best Brief Awards this year, Petitioner Madeline Abbey and Respondent Taylor Hitchin.
All right. Let's have one more round of applause for our brief winners and our competitors tonight. Thank you guys so much. You've been a great audience. The judges will be coming back any moment now to crown a winner. So just hang tight. Thank you.
Okay, hello everyone. Okay, if you could sit down. Hello, welcome back. Okay, the judges are going to give brief feedback, about 2 minutes, about both petitioner and respondent, and then we will announce the 2026 McBaine champion. Thank you.
Well, we had a very difficult time deliberating. One of the things about moot courts is that it is really exciting to see how excellent students are in their arguments in front of us. And we did not see the briefs that many of you wrote, or any of you wrote, frankly, but we really enjoy the superb advocacy here that both sides did. And no wonder you emerged at the top of the group of excellent students that there are at Berkeley Law School. So it's often very hard to make comments because you are at such an excellent level, and compared to some of the counsel that we see in our cases, you would be terrific. And frankly, you more than meet standards of excellence. So congratulations to both of you for the wonderful job that you did. One of the things, in terms of learning from experiences, judges will ask you all sorts of questions, some of which are really probing and probative and, excellent questions, and some questions that we may ask may be confusing. And so one of the things to try to do, which was done in this argument, was to try to confirm what the question really meant, which is a good thing to do because you shows that you're trying to grapple with what's concerning to the judge, but you don't want to give an answer that is not really responsive and that may be a difficult one. And I think both counsel were excellent in responding to our questions and addressing the points that are really concerning points in this case. It's a fascinating case, and there really isn't any clear-cut law. So it's interesting for those of you who haven't been working on this case. The Supreme Court of the United States actually did have a cert petition and a response and a reply, and then decided not to grant cert. So we, have it remaining as an open question. And I think I learned a lot in preparing for this oral argument, and I hope that everyone else did. But I want to congratulate both counsel for doing an excellent job, and let Justice Hartz give any thoughts that he has about the argument.
I'm not justice anymore. There's no justice on the Court of Appeals, they told me. It's just judge. It's so hard to comment when you have two really absolutely first-rate people. So I really don't have any criticisms, and I'm not going to speak to you individually. I'll just tell you a few things that you did really well, so you'll focus on it. Your demeanors, the way you spoke, just perfect. I mean, we listen to you. Sometimes it's hard to listen to an advocate, but your voice, your mannerisms were great. I thought the way you parried the questions for both of you was very good. Responding, but managing then to get to your next point that you wanted to make that we were trying to keep you from doing. And you both did very well. You were both very knowledgeable about the record. You'd be surprised how important that is. Little factual differences can make a difference between winning and losing. And to point out the useful factoids that help you is great. And you both did wonderfully on that and knew the relevant law. I'm not sure I need to point out everything that you did great, but those are things that are very important. And if you decide to make a career in appellate advocacy, I hope you'll be appearing before the 10th Circuit at some point.
Yeah, I couldn't agree more. I think the standard of advocacy from both of you is excellent. I would be thrilled again, to see you arguing before my court. And I echo in terms of what my colleagues have said in terms of everything that you did well. It was, I think all my scores were, at the top end for both of you. And it is really coming down to your very fine margin of difference that is difficult. And I would say that, the skills that you exhibited, the level of preparation that you exhibited, in terms of knowledge of the case on the record and actually answering the questions that are asked of you are so foundational, and shockingly how many times we hear oral argument in which those skills are not exhibited. So you're already way ahead of the game. And I think the only other thing that I would say is most challenging about oral argument, and that I think you both did well, is, but I would say if there was something to keep honing, and I would say this to probably every attorney who's ever appeared before me, with very few exceptions, is to anticipate the difficult questions and to preemptively address the weaknesses in your argument or your position, and knowing how to assure the judges that what they're going to do isn't going to have consequences that they don't intend. So figuring out how to do that is, in any particular case, is challenging. But I think usually when you're getting to oral argument is because there is something that makes your position difficult. Yeah.
So our task is not to decide which side is actually the proper legal argument, but to give an award to the person whose advocacy skills we thought were the better. And we were very closely divided in each of our own minds and as a panel but decisions must be made. I one time was on a moot court where there were 4 judges, and we were divided 2-2, and we were no one was willing to make cave. So this is why we yeah, exactly. But so it's very close. We admire both counsel, but on balance, in this closely fought case, we give the Best Advocate Award to the petitioner.
Congratulations to you both. And this concludes McBaine 2026. Thank you all for being here.